In the words of Mark Twain, it's easier to fool people than to convince them that they have been fooled. Karen Read proceeded to trial at the end of April 2024 for the death of her Boston police officer boyfriend, John O'Keefe, alleging that the Boston police and the Massachusetts State Police had fooled everyone by pinning John's death on her. The question on her mind was whether she could scale the tall blue wall and prove her innocence, or whether she would spend the rest of her life behind bars for something she claimed she didn't do. I'm Marina. With me, I have my best friend Laura, and this is Grim.
Oh man, it gives me like a pit in my stomach to think, like, of course, I'm always thinking if I were in this situation, it gives me just a pit in my stomach to imagine how she's feeling.
And this is just a reminder to everybody that I grew up in Connecticut and still haven't seen the Mark Twain house.
Nah, I have.
I know.
Yeah. Oh,
you said
okay.
that.
Well.
And you were like, because we were talking about somebody and you were like, Mark Twain lives in Connecticut too.
I'm not very good with anything like a substance. And so I just like to really call out those times that I was intellectual.
Okay, so we are back with the finale of Karen Read. Today we're covering her trial. I'm going to cite my sources again, but if you haven't listened to Karen Read Part 1, I do recommend that you go back and listen to that episode because this one will make way more sense. For this case, I read the 2 Vanity Fair articles, which were very biased, but I loved it. By Julie Miller, Karen Read tells her story Part 1, a murder trial in Massachusetts, and Karen Read tells her story Part 2, a new trial looms in Massachusetts. I read
They did 2 parts, so it's fair.
Yeah.
Yeah.
I was
Vanity
inspired.
Fair can do 2 parts, we can do 2 parts.
I was inspired. I also read a timeline of the Karen Read case and the story behind the high-profile Massachusetts murder trial by Matt Shuley, and listened to trial audio from Full Trial Audio, Karen Read.
Perfect.
But before we start, we have Patreon donuts. So for anybody that didn't listen to the end last week, it was like 10 minutes. So
Yeah,
you're welcome.
you're welcome for doing that at
But
the
we
end.
love you guys so much. Like 10 minutes of Patreon donuts. We love you so
Nuts.
much.
Yeah,
Okay.
there was quite a discussion on some names though, so that
There was.
contributed to some of those minutes. But
That's
okay.
I got number 1. I got it. Ready? Jordan M.
Jordan!
Woo! Jordan! We love
you,
so
Jordan.
much.
Thank you.
Haley.
Haley,
Woo-hoo.
we love you, Haley. Thank
You're the
you for being a
best.
Patreon, Haley. I was trying to think of new things.
Life is
Haley.
like a
Thank
box
you.
of chocolates. Anna S.
Anna.
Thank you so much.
Anna, we love you. Thank
For
you.
Marina and Forrest Gump, we really mean it. We love you. Nancy.
Thanks, Nan.
We
We
love
love
you so
you.
much, Nancy. Okay.
Oh dear.
It's Joan N or Joanne N? It's
Okay.
Joaan.
Okay, Joanne.
Joan.
That was
Joanne.
was that Samantha or something?
Oh,
that I did?
Samantha.
Yeah,
Yeah.
Maybe she's friends with Joanne.
Joan, Joanne,
Joey,
Joan,
Jojo.
Jojo, and we love you so much. Thank you so much.
Thank
And
you.
I'm so sorry I don't know how to pronounce names.
You can always correct us. It's okay.
Yeah, you know what? For people that do, and they're like, you ruined my name, we're like, we'll say it again. I'm so sorry. Another Haley. Woo! Thank
love
you so
you,
much,
Haley.
Haley. You're
Thank
the
you very
best.
much.
Oh, and actually, neither of them had an initial. So, Haley squared. We love you both so much. Yay, Patreon. Diana C.
Diana. We love you, Diana.
Thank
Thank
you
you.
so much. Colleen C.
Colleen C. We love you, Colleen. Thank you so much.
so much. Alyssa K.
Alyssa.
We love you so We love you so much. Thank you. And Erica Y.
Erica E. Erica. You
I
know?
was like, what?
Erica Y.
I was like, there's no E.
No, I know. You know,
She's like
she's
Erica-ish.
very Erica. Erica.
She's not Erica-ish. She's Erica E. Anyways, okay.
Thank you. We love you.
Thank you guys so much. We love you so
you.
much. You're the best. You are the best. Whoa, 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 whoa.
Only in the morning.
Okay, so this is a quick reminder. When we last left off, right before Karen's trial, the feds turned over more than 3,000 pages of findings, including, but not limited to, more disgraceful text from Trooper Proctor, expert findings that the damage on Karen's car was inconsistent with a pedestrian accident, that Brian Albert destroyed his phone the day before a protection issue was ordered to preserve the contents of the phone, and that Brian Higgins and Trooper Proctor spoke on the phone for 22 seconds at 2:22 a.m. 22222, although they said it was a butt dial. Okay, so now on to the trial, and as you can imagine, trial proved to be a circus. On one side, you had the Free Karen Reed group.
Yeah.
Like, I'm not kidding. People, this was not a close call for people. Like, they felt
I get it.
very strongly
I get it.
on both sides.
Yep.
So you had the Free Karen Reed group, and then on the other side, you had the Justice for JJ group, and one person was like, I don't think they realize that both people are supporting the same thing.
The truth?
Yeah. Yep.
Oh, they were saying justice for like John.
Justice for John, but they're saying like they don't understand that the Free Karen Reed group is like, she wants them to answer for who did it too.
Yeah.
So,
well, and I'm positive you're giving me every piece of information. Most people are not getting most of the information.
Right.
They're reading whatever blips they
Yes.
want, and then they're reading further things that confirm the opinion they have. You know what I mean?
Right.
It's kind of like politics. And you just get that confirmation of the thing you're reading. And I guarantee you, if you got the flip side of this, if you actually chose the other side and read me the whole thing, I would probably be right there with you if it were presented to me in that way. And that's what they're getting.
but you know what's crazy? It really is like politics, like not talking about anything specific,
Right.
but I went into Reddit a little bit to see like what people were thinking. It is a scary place, but I wanted to see what people were thinking and what they were talking about. And because I'm looking at it on a, like from a legal front and like the issues that are being raised and the evidentiary issues. And I'm just wondering what like lay people are thinking. And one of the posts, I actually looked up like evidence against Karen Reed to be like, what are people looking at and being like, she's so guilty.
Right.
And people were like, you know, it's so clear to me that she killed him. Like she said, I hit him on the scene.
Yep.
And there were like these other points that like they didn't come to fruition at the trial.
Right.
And people were like commenting, they're like, I don't even think you're watching the same trial. Like
Exactly.
two people watching the exact same thing are still taking different things
and
from the testimony.
And again, like we love this shit. So we're like in the details. We're figuring things out. We're asking questions. Like most people are not. Okay, everybody listening is. But most people are not. Most people are just getting like, again, that headline that they see and they're like catching something. Or and like at best they're reading news articles. More likely they're reading Facebook posts that are completely biased and incorrect and nobody like, anyway. So I can completely see why there's two sides and why if you're someone who only got that picture and that world that you would feel that strongly. So
some
but
people,
you're wrong.
Some people are looking at it with rose-colored glasses and other people are looking at it with poo goggles. That was from a show and it cracks me up. I just had to work it in.
I like that.
Poo goggles.
Yep. Okay.
Supporters of Karen raised $5,000 to put up a free Karen Reed billboard across from Gillette Stadium. The billboard owner believes so much in Karen's innocence that he left it up for over a year without additional payment.
Oh man.
Crazy.
Jeez. There
There was also a blogger, Aidan Kearney, called Turtle Boy. He garnered attention during Karen's trial, being an outspoken advocate for her. He even confronted some of the Alberts and McCabe's. He may have been a little too zealous in his support of her, being arrested and charged with several counts of witness intimidation, although he claimed he was just exercising his First Amendment rights. As part of the investigation against Turtle Boy, they found 189 calls between him and Karen Reed, which again, he called journalism. The DA convened a grand jury a month before Karen's trial and tried to get her indicted on charges of conspiracy to commit witness intimidation.
Oh, jeez. Oh, that's scary.
But the grand jury did not issue an indictment.
That's good.
They were like, this case is looking bad. Let's see if we can get her on something else.
Yeah. Oh, yeah. But that's scary because, like, that's anyway. Yep.
Have you watched Juror number 2 yet? Mm-mm. Oh my God, you have to watch it. There's a couple things that keep coming up in this case, and I was like, oh my God, it makes me think of Juror number 2. But it's like, if you commit a crime, it's like the crime may not be the thing that gets you, but you're gonna get fucking nailed for like evidence tampering and stuff like that. Like anybody in this case, like, say they did get into a fight and he accidentally died, whatever, like, maybe you'd pick up manslaughter charges. Like, the evidence tampering across it would take them all down. Like, it would be...
Exactly.
It'd be done.
It also makes me think of 12 Angry Men, which I just recently rewatched a video of, like, a movie version of it. And I love that movie. I think I've talked about this on the podcast before, but like that is one of the things I went and saw it, like, I don't know, for a school play. Like, we went as a school to see the play version. And I love it because it is so, if you haven't seen it, the concept is obviously it's a jury room.
Yep.
And I won't spoil the whole thing, but like it's talking about how the pieces of evidence can appear very differently.
Yes.
Like you really have to talk it through.
Yep.
And I always think like, that's why I love doing this, because I love trying to think about like, what is the reason? Like, I'm only hearing the information as you're presenting it. Like I'm only in my own brain. I can only think of it a certain way. So if you haven't watched that, I think it was like 1950 something.
Okay, well, you have to watch Jury Number 2. It's from 2024. Okay.
That's on brand for us.
You're having a tough year. You didn't hear about this trial. It's from way back in 2024. You haven't seen this new movie. Like, it's fine.
I've been a little busy. Okay.
Yeah, sure.
Okay.
Karen had a top-notch defense team lined up, although she made efforts to cut costs where she could. She cut deals with Uber drivers to get them to and from court.
Oh, man.
She stayed in the same hotel as them through the trial to maximize prep time, but she paid $1.2 million leading up to and during the court proceedings.
Oh,
and as she said, she was fighting for her life. Can you really put a price on freedom?
Can you like get a loan for that? How does that work? Like, you probably can. You could probably, I'm sure you can get like, you can do like a HELOC, or you can do like that sort of thing.
She borrowed from her 401k. She got money from friends.
But you can't like you can't do like a personal loan, can you?
I mean, if you have the
credit or
credit
whatever.
and the assets or whatever, the collateral is the word I was looking for.
Yeah.
Sometimes words are really hard.
I know. Yeah.
Okay. Karen's trial began on April 29th, 2024 with opening statements. The theme for the Commonwealth, they opened: the defendant, Karen Read, is guilty of murder in the second degree. Striking of the victim, Mr. O'Keefe, with a car, knocking him back on the ground, striking his head on the ground, causing the bleeding in his brain, swelling, and then leaving him there. The defense came right out with their theory in the opening line of their opening argument. Karen Read was framed. Her car never struck John O'Keefe. She did not cause his death. And like, it's just wild to say that in court. Like, it's intense to put forth that theory.
Really?
Like, you gotta...
Why?
Because if you're gonna allege corruption by police officers in a court of law, like, you better have something.
The concept that he literally said that she was framed.
Yes.
That part. Yeah.
Like, that your defense is that she's being framed by law enforcement.
Yeah.
Like, you better have something. And you're not going to find a lot of lawyers that are going to go out and say that unless they have something.
Right.
But crazy. The prosecution produced 68 witnesses, at least 9 of whom were related to Brian Albert by blood or marriage. Karen Read had only 6 witnesses. Some of the trial was a he said, she said, while other parts of the trial was a battle of the experts. I'm not going to go through everybody. I didn't.
You wanted to, though. You did text me and say, I want to give you every single witness. Yeah.
There was
at this point now I want it.
I know.
So I see why, but I'll accept your summary.
There was like an hour on like one screenshot. They're like, did you know that you can change the timestamp? And she was like, no. They're like, did you know this? She's like, no. I'm like, okay. Anyways. All right. So the first responders to the scene were called first to testify. At least 4 paramedics and firefighters testified that Karen said, I hit him, when asking for background information about John's injuries. For what it's worth, Karen has maintained that she was asking, did I hit him? Could I have hit him? I hit him? Like
with a question mark.
Yes,
Yep.
That's what she says.
Yep.
That's what she said. Lieutenant Paul Gallagher of the Canton Police testified early on in the trial about the processing of the scene where John's body was found. After John's body was removed from the scene, the police used a leaf blower to clear some of the snow, as I mentioned before. They found pieces of broken glass and some areas that were darker red. The police thought it might be blood in the snow, so they went and got red Solo cups from a neighbor's house, scooped those samples into the cups, and then put them in a paper Stop and Shop bag.
Come on.
Okay.
And this is, like we said earlier, even if everything's kosher, do it by the book.
Okay.
Because now you wouldn't have this question.
All right, here's the thing. if you're going to do that, just don't do it. Like, don't do it at all.
Yeah.
Because those samples are worthless.
That's what I'm saying.
They're worthless.
Yeah. Yep.
So, like, if you're going to do it like that, just don't.
Don't waste your time.
Just don't do it.
Yeah. Yep.
Lieutenant Gallagher confirmed that it was his team that searched the area. There were no pieces of taillight found on the scene. 4 officers searched. Also, I forgot to include it in my notes, but the grass. This was like a topic of much debate about they could see the grass underneath him. So he must have gotten on the lawn earlier in the night because his body wouldn't have melted the snow. And this was also on Reddit. People were like, I go out in a snowsuit. Okay. Even if there was, say there's a lot of snow on the ground, he's not wearing anything thermal.
Right.
He's losing all of the heat into the ground to melt the snow.
Yeah.
So I don't buy that.
No. Yeah, I'm
also a
stuck
scientist.
Marina's Science Corner. That was Lisa's Science Corner,
Oh,
right?
yeah.
That
Yep.
one's legitimate.
Yep.
We miss you, Lisa. We'd like your next case. Okay.
Yeah.
So I was also stuck on earlier. You said they used a snow blower to clear it, and you just said leaf blower, and those are. That's significant.
It was
to
a
me.
leaf blower.
Okay,
Sorry.
I almost commented on that because I think leaf blowing snow when it's light and fluffy is fucking brilliant.
Yeah, that's what they did. I'm so sorry. It didn't even occur to me when you were making that face. I was like, they were just like blowing the snow away.
Yeah. Well, and it doesn't, I don't quite know. It doesn't, I know it's significant in that what it's doing is very different. Like it's chopping things up or it's not. But I just wanted to call that out. But I haven't processed exactly what that does. Cause part of me is like, okay, if it were like big pieces, if I buy into that they didn't plant the evidence, then I can think fine, maybe it like did catch and get blown away with the rest of the snow.
Yeah.
I don't know.
No, it was a really big piece. Yeah. One of them was like the size of a salad plate.
Oh, that's
like
a big
it's
tail
a
light.
big, it's one of those big boxy black
Okay.
SUVs
Yeah.
with a huge tail light.
Yeah. Okay. All right. Anyway.
Yeah, I'm pretty sure it was a leaf blower. Now I'm like, was it? I don't think it was a snow blower. I think it was, they were like
That
blowing
makes
it away with a leaf blower.
makes way more sense. Yep.
I'll just make stuff up. It's totally fine.
It's fine. I mean, it's 4 letters.
They are.
Snow. Leaf.
Okay. So speaking of taillights,
Yes.
during the testimony of Michael Proctor's supervisor, Sergeant Yuri Buchanan, the prosecutor played a video showing Karen's vehicle in the Canton PD garage, showing that no one was near the right tail light. Although the video did show Michael Proctor behind the left tail light in the video, and Yuri identified the man in the video as Michael Proctor. Mm-hmm. The defense said that the video had not been turned over to them during discovery. But while viewing the video during the testimony, the defense noticed something.
Oh, tell me it was flipped. Tell me it was flipped.
The word police
Was backwards.
was
Or
inverted
Yep. Fucking
on
knew
the
it.
vehicle in the garage.
How is that not tampering?
So the right tail light was actually the left,
How is that not tampering?
and Michael Proctor was near the tail light in question. Wait, it gets better. Notably, the timestamp was not inverted on the video, which means that someone had to take the timestamp off, invert the video, and then put the timestamp back on.
It wasn't an accident. It wasn't a butt dial.
No. Sergeant Buchanan agreed that the video was inverted, but said he didn't know how that occurred, and he maintained that it didn't change anything.
It didn't change anything? Mm-hmm. No, it literally changed everything.
Changed everything. Mm-hmm.
Oh, I have like goosebumps and my face is flushed. I'm verklempt.
Enraged.
I'm verklempt.
Enraged. Okay. Dighton police officer Nick Burrows was called to testify by the Commonwealth. I think they were trying to get ahead of the taillight allegations to say that the taillight was damaged before Michael Proctor took possession. But Officer Burrows testified that when he saw Karen's right taillight at 4 p.m. on January 29th at Will Reed's house, the taillight was cracked and had some damage. He said a small piece was missing, but it was not completely damaged.
Not a dinner plate sized or salad plate, whatever you said.
Nope.
Yep.
Defense had no cross-examination questions for him. So basically they were like, yeah, that helps us. Mm-hmm. There was testimony that over the course of the next 3 weeks, 47 pieces of taillight were found at the scene.
Come on.
And you need to pause it so I could show you the taillight photo. Okay. Now I'm going to show you on the left is the piece of taillight that was found in the snow. And on the right is a picture of the tail light damaged
Like on the car.
after the police said it. Now, I want you to look at the picture on the right and tell me if you would look at that and say, that is cracked but not damaged.
It's missing completely. Oh my God. There's no scale on the, like, there's no sense of scale on the left.
No.
So that's hard. But
No.
come on.
It's
It's like the
lit-
size of the back of the car.
It's like literally missing. You would not look at that completely missing taillight
No.
and say, that has some damage. It's cracked but not completely missing.
Can you imagine being Karen and just being like, if I didn't fucking back into that stupid fucking car.
Oh, I know.
You know, and it's not
I
because they
know.
would find something else. Like, it's, you can't think that way. But that is what I would be thinking is like, you think about these, like we were
Any
talking.
of it. The voicemails.
Yeah.
Saying, did I hit him?
Oh, yeah. Like,
any of it.
oh my God. Yeah. It's just, it's all these little things that amount to you just, and again, you can't think like that because
Right.
it's what it is. And they would have just found something else.
And now I wonder if she hadn't said, did I hit him?
Would they have even thought of it?
Would the police have come out and been like, holy shit, he must have been attacked by somebody?
Right.
You know what I'm saying? Like, I bet you they
That's what I
wouldn't have
mean.
even said
Right.
she hit him.
Right.
They probably were like, oh, damn, this is going to work. Okay, let's go for this. Like,
And you know, to give them, I'll even give them a modicum.
Modicum.
Why do I always want to say crumb? Because it's a crumb.
modicum?
It's a little crumb
Modicum.
with a crunchy R. But even a little bit of credit in that, like maybe it did seem like she did it. Maybe it did seem like they heard I hit him. They saw the crack. Like,
yeah.
fine. But that's why, as you said, you investigate the evidence,
Right.
not the person. So, okay.
Right.
Yep.
And they also, like, I didn't include a lot of this. There was a lot of, like, personal stuff between everybody about, like, who's friends, who went to parties, whether the firefighters knew each other, like, whether the
Yeah.
firefighter was
Yeah.
good friends with the Alberts. Like, Jennifer McCabe said that Karen said weird things. Like, at one point she said, I need to think of the bad times. And she was like, that's a fucking weird thing to say. And Karen,
is a weird thing
and
to say.
It
Yeah,
probably
fair.
was. It probably was like, she's trying to be like, okay, I can get through this. Like, just remember,
Yeah.
you know, like people say weird fucking
Yeah.
shit when they're grieving. I
And
didn't cling.
That's why they had 68 witnesses.
Yeah. I didn't cling to any of that because there's such big pieces of evidence
Yeah.
that I think the case really comes down to.
Yeah.
I don't think it comes down to like the weird thing that
No,
Karen said.
no.
No. So Lieutenant Brian Tully was also called to testify about the tail light. He had evidence bags labeled as having 3 pieces of tail light in them, 2 red and 1 clear. During direct examination, he was asked to remove the pieces. He pulled out 2 red and 2 clear. The defense noticed. They asked him to empty the bags on cross-examination, and Lieutenant Tully pulled out 3 red and 2 clear.
What?
That is either super sloppy police work, or the defense argued in closing that it's evidence manipulation. He said that's how 0 taillight pieces turn into 3, then 5, then 47.
Yep.
Like it's just a magic trick.
Exactly.
Yep.
Oh my God.
I think that's sloppy.
Yeah.
Okay, Jennifer McCabe testified to the events of that night and the next morning concerning what appeared to be that damning Google search on how long would it take someone to die in the cold. She denied ever making that search prior to 6 a.m.
Of course.
Said she made it at 6:30 at Karen's request. Denied deleting the search. Denied that she made calls to Nicole.
But we know the search was deleted, right? That was a known thing. Like you can't. Okay. All right. Yep.
I'm not a tech expert, but I'm not buying it.
No. I am. I'm just kidding.
And she denied deleting the phone calls, said she didn't speak to Nicole. Like, they're just like, none of it happened.
Okay.
Also related to Jennifer's Google search, the Commonwealth called an expert who said that the 227 timestamp, I mentioned this before, but it's not indicative of the time of the search. It indicated when Jennifer opened up the tab in which she ultimately made the search, which I don't think that's right.
But if you also like, if you are the type of person to open a search, like I think there are some people who open windows and just leave them open forever.
I had 500.
So, yep. Yep. Imagine sharing grimcrimepodcast@gmail.com with Marina. It's fun. But if you're the type of person that opens that, it probably wasn't opened. It would have already been opened like years before. Probably.
I wonder what my data would look like. They'd be like, my God, we can't even go through this.
Because you probably have the same 500 tabs that have always been open. Like, you know what I mean? Like, if you're the type of person to leave it open and then later search, because she,
Right.
But if you're like me and you open one to do the search and then close it.
Oh, really?
Like, yes.
Oh, no.
Have you seen my house?
Oh, no.
Yeah. No, but it's all bullshit. It's all bullshit. That's what I'm saying.
That's from my cousin Vinny. Everything that guy said is bullshit. There was forensic testimony that focused on the tail light, a glass found on the bumper of the SUV, a piece of glass, not a glass, and a hair that was found on the SUV. The prosecution's version of events was that John was holding a drinking glass from the waterfall when he was struck. Pieces of the glass were found at the scene as well as on the bumper of the SUV. The shards on the bumper were tested and they had John's DNA on them. Defense pointed out that the pieces of glass found on the bumper were driven on the highway 60 miles per hour in blizzard conditions after Karen's SUV was taken. And same for the one single hair that was found on the vehicle, which the defense called a magic hair.
Yep.
Interestingly, the glass found on the bumper did not match the cocktail glass, but it did match glass found on the scene. Interesting. Who had access to the vehicle in the scene?
Yeah.
The prosecution argued that it stayed on because it was frozen there. Oh, sorry. This is talking about the hair in the glass.
Yep.
So the prosecution was like, it was frozen. Like, that's why. It wasn't magic. It just was stuck there.
It's a good argument.
Forensic testimony also indicated that John's DNA was found on outside pieces of the taillight and that microscopic pieces of the red and clear taillight were found on John's clothing. But no blood and no DNA was found on the vehicle or on the inside pieces of the taillight. Sorry, there was DNA found on the vehicle, but not inside the taillight. No blood found on the vehicle or inside the pieces of the taillight.
Which makes perfect sense because that's his, not wife, but essentially wife's car. Of course,
you're going to find my DNA all over my husband's truck.
Like, exactly, but not inside the taillight.
Where you would expect it to be if it exploded on his arm. Yeah. Mm-hmm. Yep. And that's
and head like so their argument was like he got hit in the arm and then fell backwards. Like
I'll get to that.
Okay.
I'll get to that.
Okay.
There was also testimony about Karen's BAC. I mentioned that on the morning of the incident, it was 0.09%. An expert was called to walk that back to say at the time of her accident, her BAC was between 0.135 and 0.292, which to me, those are very different. Those are very different. Mm-hmm. But concerning her SUV, Trooper Joe Paul, who was considered a crash deconstructionist, he testified that the data, I can't. Okay. The data indicated that Karen backed up the SUV a total of 62.5 feet going 24 miles per hour. He said the taillight hit John's arm, causing the scratches, and that his hand holding the glass is what hit near the taillight, and that's what would have caused the dent near the taillight.
And he then flew backwards.
Yep. The right arm is what collided with the SUV and launched him 30 feet.
Or the 62 feet at 24 miles an hour is probably how I would back out of 24 miles an hour.
That's really fast to back up. That's like really fast to back up.
I was going to say backing down and into the car, but like I feel like the taillight would have been destroyed.
Not the taillight. John's arm would have been destroyed.
True. Yeah. Okay. All right. Anyway,
so the scratches,
that's crazy.
The scratches on his arm were alleged to be from the taillight shattering when he was hit by the SUV. But the arm on autopsy showed no significant bruising, no fractures, and no broken bones.
Also, couldn't you look at like what the scratches are, and wouldn't glass have wouldn't you be able to tell like I would think that glass would be much sharper, cleaner cut than like a dog or something like that. That would be a much rougher cut.
Well, it's not glass; it's plastic.
Oh, true. Okay, that's true. Yeah.
But so this is the problem.
Still, yeah.
This is the problem with conspiracy or, thinking that evidence is planted or tampered with. Like people were like, okay, well, there was taillight found on John's sweatshirt. Trooper Proctor had it for 6 weeks before it was put into evidence. It was like in his vehicle.
Yeah.
You just can't trust anything.
Right.
It just taints. It's the fruit of the poisonous tree. Like everything is tainted.
Yep.
You couldn't ever get me to find her guilty of anything beyond a reasonable doubt because there's a cargo ship of reasonable doubt in this case because of the actions of people involved.
I'm really desperate for the end of this because not because I want it to be over.
You've been
because
like twirling your hair and like,
I know, because I'm trying
Yeah.
not to twirl the microphone cord. But I need to know. I need to know.
we're getting there.
Because again, clear as day to me, but
Yeah.
that's how it always works in these fucking cases.
Yeah.
Go on.
So now before I break that down further, I just want to add that the medical examiner who performed the autopsy also testified. The cause of death was blunt force trauma and hypothermia, but the medical examiner could not opine the manner of death. She agreed on cross-examination that his injuries could be consistent with a physical altercation and that his injuries were not what you would usually see with an auto versus pedestrian accident. Yeah.
Yep.
John had skull fractures and broken ribs consistent with CPR being done.
Oh,
but he had no broken bones, injuries, bruising anywhere from his torso down. No marks on his legs, hips, stomach.
Yep.
Nothing.
Yep.
You launched thousands of pounds of SUV at this man at 24 miles per
Yeah.
hour.
Yeah.
His arm takes the brunt of it and it doesn't break. Yeah. Okay. So like this was my next paragraph, but like take the cover up out of it. Take the
That's
frame
what I
job
mean.
out of it.
Yep.
Look at this objectively. You back into this man in a full size SUV at 24 miles per hour. Those are his injuries.
And I also, did you go to the maps? Is there enough room? Like, what is this? I'm envisioning a relatively small neighborhood.
It's a street. She has the street.
But like, I would want to know. Okay, so all right, that's fine. I guess I'm curious what angle he was at. Like, where? Do you know what I mean?
There was I didn't go down the rabbit hole on that, but like
What the fuck? I'm just
sorry.
kidding. I'm kidding.
So she said she was performing a K turn, well, a 3-point turn when she did it.
You're not going 62 feet in a K turn.
Well, you're not going 24 miles per hour in a K turn either.
No, you're not. That's what I'm trying to say. And then I'm curious, like, where his body, like, you
Although
need to go to the maps.
if you were doing a K turn and you like slammed it at 24 miles per hour, if you did hit him, it would launch him into the yard.
Well, sure, but but
I
again,
don't-
is that where, like, is that how his body, like
He was found
were his legs facing the street? I guess is what I'm saying.
I don't know, like that
She's
description
drawing.
wasn't great, but like there was a flag here and there was like a fire hydrant here and like the driveway was here and
Uh-huh.
I think he was found like here.
Oh, and she was going like that way. Okay.
But then some people were saying like she didn't even need to turn around to do a K turn, but like the data showed she backed up. So I'm like,
Very weird.
yeah, but
It's almost like the experts should
And then
like
they were
look
like-
into all that.
and then they were like, well, how did his head get injured then? And he's like,
Right.
he might have hit it on the curb.
Right, and like that specific
While you're
of an-
being
of a-
launched?
that's what I mean. Like, is it? Yeah, I don't know.
And his shoes did fly off.
Oh,
They found one of the shoes at the scene.
that's weird in general. Even
It
in
is.
either possibility.
But there was something about like the shoe wasn't there when they searched originally. So I think
God.
it was like another planted thing. The shoe was
But that
weird.
doesn't make sense in literally either. Like, even if it is the fight concept, like, why were his shoes off? That
I
doesn't
don't
make
know.
sense.
Because cops know that your shoes fly off when you're struck by a vehicle.
Okay.
Right?
All right. Yeah, I don't even.
Massachusetts, they're all Dane Cook fans up there,
Yeah.
right? Okay, anyways.
I like how you got a little bit of a New York accent there.
I was at New York. I was
Yeah.
trying to do Boston.
Yeah, no.
Whatever. Of my many talents, accents are not one of them.
We know.
Okay, after 68 witnesses, the Commonwealth rested its case. Then it was the defense's turn. The defense's first witness was a doozy. The defense called Canton Department of Public Works plow driver Brian Lucky, I think it's Loughran. It's Loughran or Loughran. It's Loughran.
Okay.
I heard it said, and then I couldn't remember. I think it's Loughran. I'm going to call him Lucky since there's too many
like it.
Brians in
Yes.
the case. And that's what he
Yep.
goes by. Almost threw my pen. Fit of joy.
Yeah.
Okay.
Just twitched.
Lucky was driving a snowplow known as Franken truck that night. I guess
amazing.
it's old and has like a bunch
Yeah.
of pieces from other
I
cars.
love that.
He testified that he's very careful when driving the monster plow truck, staying aware
Mm-hmm.
of side traffic, pedestrians, and animals. Lucky testified that he made 3 passes by 34 Fairview in the early morning hours of January 29th, and there was no body on the side of the road on that lawn. And he didn't say, I didn't see a body. He said there was no body. He
I
said
have
he has a
goosebumps.
high vantage point and that his truck has bright lights.
And he is being vigilant, like intentionally,
He's
whereas like a
looking.
normal like person driving, like you
Right.
kind of zone out, whatever.
Yep.
No, he is looking.
Yep. No.
I need to look up this neighborhood because I need to understand if we're
Okay.
talking like a tiny little
34
street.
Fairview
Okay.
Road, Canton.
I'm gonna do that.
Okay, I'm gonna keep talking while you do that.
Fairview
Yep.
Road.
Yep. Drive.
Everyone who's listening to this is like, yeah,
Might be
road,
drive.
road.
Is it road?
Yeah. Okay, it's a decently, it's like decent lots, like what maybe half acre lots. So I was picturing more like a much much
really
tighter.
city? No.
Yeah.
No. It was
Okay.
pretty residential.
Yeah, and it's a pretty big road, but it's relatively wide. Like, okay, so something important for because again, I'm picturing like lots of cars, like maybe he can't see
No.
past. It's literally like there's not a single tree in front of their house.
Yeah.
Like if he was in like this, I'm looking at the right thing,
Yeah.
right? If he's in this, I love the maps. I love them.
Oh my God.
But if he's in this yard, you're going to see him, especially
Right.
a body on snow.
Yes. Well, there was somebody else that when they left, I didn't include this either, but somebody testified that when they left the house, they saw a black blob. Oh, but scroll, use the arrow.
Oh, because I was going to say they have it blurred.
They
Oh,
have
that's
it blurred,
funny.
but if you move the
It's
arrow
a cute little house,
one,
actually.
it is.
I see what you're saying.
Someone
Oh,
was murdered in the basement though, so you don't like that.
No, I don't. Drops the resale. But no, this is you would be able to see so
Yes.
clearly.
Well,
okay.
and nobody's parked on the road because it's a blizzard, so there's probably parking
Yup.
bans. So
okay.
somebody had testified that when they left, they saw a black blob on the lawn, and the defense is like, that's just made up. Like that's just somebody.
Yeah.
I think that's just somebody wanting to be helpful.
Yeah.
But yeah, bright lights. He's looking.
Yes.
He's like, there is no body. Which, by the way, Michael Proctor had gone. And he was like, oh, like, I don't think there were plow trucks out that night. And the guy was like, no, I like could give you this guy's
3
name.
passes.
And then got the guy's name.
And it's a double yellow, which means it's not like, because I live on like a tertiary road and like we're lucky if they come by once.
Yep.
This is a double yellow. Like they're definitely plowing. I'm
plowed.
all about the maps.
They
Okay.
plowed.
Okay.
Yep.
Yep.
And he also testified that when he passed the house for the second time around 3:15 a.m., a Ford Edge had been moved in the street front of, I wrote that weird, in the street in front of the area where John's body was ultimately found. Now Brian Albert drives a Ford Edge. Lucky said it was normal protocol to call in a vehicle on the side of the road. I'm guessing when there's a parking ban.
Yep.
But he didn't call in this vehicle as a courtesy to the Albert family.
Oh, that's so that's even more interesting that he knew them.
He did.
Too.
Yeah.
Okay. Yep. Okay. All
Yep.
right.
The defense also called Dr. Marie Russell, a retired emergency room forensic pathologist. She testified that the injuries on John's right arm were consistent with a large dog attack. The state did try to address this theory. Words are getting real hard. The state did try to address this theory. They swabbed John's clothing for dog DNA, but they didn't label where they swabbed. Like, have you ever seen, I don't know if you would have seen this, I've seen it from court cases, but like, when you have a DNA sample that's taken, there's normally a picture of the evidence and they will like specifically
Yep.
draw a circle
Yep.
and be like, this is where the swab was
Yep.
taken. They didn't have any of this for this DNA. They swabbed the clothing, but not the wounds.
What? Okay.
Like you'd think you'd swab the wounds. Anyways, so they swabbed the clothing. They sent it out to be tested. The testing found that there was no dog DNA, but there was pig DNA. And I was like, that's weird. But they said that could come from pork or bacon products. So more likely
interesting.
that John had some kind of pork for dinner than the fact that he was attacked by a pig.
That's that reasonable doubt there. Yes. Okay.
Yeah. They're like, Babe was in the basement. That was, I like how I just combined Babe and Wilbur. I'm like, Wilbur. Okay. The Celsius is wearing off, but the cocaine has not yet kicked. Okay, anyways.
She's kidding.
I am totally kidding, but oh my gosh. I think my brain is melting.
I think unless there's cocaine in Celsius, which is to me,
You
jury's
did
still
say
out
that
on
this
that.
morning.
Yeah,
You did.
Jury's still out. Yep.
Okay. Defense also called Richard Green, who I mentioned above. Commonwealth sought to discredit him and challenged his analysis of the data. For what it's worth, although this isn't evidence at trial, Vanity Fair spoke to, I'm going to ruin this name, I think it's Umit Karabiak, a PhD at Purdue's Department of Computer and Information Technology, who specializes in iPhone artifacts and the limitations of digital forensics. they were asked to evaluate the prosecution's expert testimony as well as an affidavit from Richard Green. They said, based on my research and expertise, I concur with what I see in the affidavit from Richard Green. Though the browser tab was opened earlier than the searches, the timestamp for the search items is recorded for searches and stored in the database, not the time of the tab opening. They also noted that Green additionally verified the search times with associated WAL files, which means write-ahead logging, that are occasionally overlooked.
Like I said, it's not a matter of, it's
Somebody
not
knows.
a question.
Someone,
it's like,
is there a podcast?
Yeah,
Someone knows something? That's
Yes,
a podcast.
yes.
Someone knows something.
it's true.
Yep.
Okay. All right.
And
Yep.
then there was the data from John's Apple Watch about the 80 steps, 3 flights up or down.
I'm so curious what the rest of the data in that is.
And then there was also combined testimony of the fact that there were 36 steps and 25 meters moved with John's phone at 12:32 a.m. And they were saying that Karen had to have left that property by at least 12:30 because her phone connected to John's Wi-Fi at his house at 12:36, and it's at least a 6-minute drive on a good day.
Oh my God,
They're
I love
like,
data.
so he was up and moving after. Like if she hit him and he flew, like,
Oh my God.
then either somebody picked up his phone and moved it and knew he was in the yard dying, or he was still alive and moving around.
How? I need to know the
Data.
verdict.
Okay.
No, I need to know the verdict
Okay.
because it's so like how that alone for me, because connecting to the Wi-Fi, like, you can't make that up. That
No.
the drive is what it is.
I know. I know. Waze was involved.
See, I'm telling you, it all comes down to the maps.
If she had used MapQuest, she would have been okay.
No, she would have been there 3 days later.
She's like, guilty on all counts. After the defense rested, both sides gave closing arguments. The defense theme was to say, the state wants you to look the other way. Look away. Ignore all the inconsistencies, conflicts of interest, mishandling of evidence. Just look the other way.
I'm so stressed because I'm worried that, like you said in the very beginning, I'm worried that going after the conspiracy side versus just pointing out things like we were just talking about, I'm very worried because I didn't think of this until just now, but the jury is probably also, I mean, probably a mixed bag, but probably also most people are pro like state police. Like,
Right,
you know what I
right.
mean? Like I'm nervous. I'm nervous. Okay, go on.
Okay. The Commonwealth's argument was to look at the evidence and testimony which showed that Karen Read hit John and left him to die. The case was turned over to the jury midday on Tuesday, June 25th, 2024. On Friday, June 28th, the jury sent a note to Judge Cannoni indicating that they were deadlocked. The judge urged them to continue their deliberations. On Monday, July 1st, they sent another note that said, this is so eloquently written for a jury. Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. I'm like, did the 4-person have a PhD? Like,
For
that
real,
is
it's beautiful.
like poetry.
Yeah.
At that point, the judge agreed to give a Tui Rodriguez instruction, which is the Massachusetts equivalent of Connecticut's Chip Smith instruction, which we've talked about.
I didn't learn. I don't remember.
I'm going to
what
tell
that-
you
okay.
again.
Okay, I did not. I listened, but I did not learn.
So she gave the Tui Rodriguez charge at around 11 a.m. And what that does is that instructs jurors to reconsider their positions while taking into consideration the opinions of others with whom they do not agree. So in essence, the instruction tells jurors that the verdict must be their own verdict and that they shouldn't just agree or merely acquiesce, but they should also examine the issues with regard and respect for each other's opinions.
Which you really probably should have done from the very start, but that's okay.
Some people call it judicial arm twisting, but despite the instruction, the jury sent another note the same day that they were at an impasse, hopelessly deadlocked.
Oh my God.
Judge Cannoni declared a mistrial, and with that, the whole ordeal was over. The prosecution indicated its intent to retry the matter, with the defense indicating that they would continue to defend against the blue wall.
That's it?
No, there's more. Here's where it gets interesting. Okay, you're like, it wasn't already interesting? This is fascinating to me.
That means it's legal.
Within a few days of the trial, 5 jurors discussed how they were disturbed by the outcome of the trial. 4 jurors contacted the defense team directly. They told the lawyers that they had agreed unanimously to a not guilty verdict on the second-degree murder and leaving the scene charges. The only charge on which they were hung was the manslaughter charge. A 6th juror was interviewed by Turtle Boy and said that 2 jurors had wanted to contact Judge Cannoni during deliberations to let her know that they were unanimous on those 2 counts. But the foreperson said, apparently, they needed to be unanimous on all counts, which is not right. The jurors believed that the foreman knew what he was talking about and also knew that the foreman was the only one permitted to contact the judge.
Wait, question. I'm raising my hand.
Yes, Laura.
How does is the 4-person randomly selected? Is it
They,
are they
vote.
part of like the regular so
It's
could
a
he have
jury
been-
member.
Okay, right, but they can't so who decides who's the 4-person?
The jury.
Okay, all right.
So,
Okay,
if we got into a room, one of us would be like, I'm willing to do it. You know? Like that. It would be that
but
person.
I'm asking because that person wasn't.
I feel like it's a
he or she
plant.
wasn't.
It could be a
yeah,
plant.
well, that's why I was asking. Okay.
It could be.
Or it could be somebody who is on the Brian side, whatever.
Yep.
You know. Okay.
Okay, so juries are hung only on the counts that they are hung. They do not need to be unanimous on all counts.
Oh my
So,
God.
had the judge asked, "Are you hung on all 3 counts?" And the jury had said,
You are throwing
through my
your
pen.
pen now.
And the jury had said, "No, we have an agreement on counts 1 and 3." The judge could have entered verdicts of acquittal on the second-degree murder and the leaving the scene charges. And it would be double jeopardy for her to be tried on those charges again in the next trial, if there was a next
for the
trial,
manslaughter
for the
one.
manslaughter charge. But nobody asked. And the notes didn't really make it seem like they were,
No.
united on one piece of it. But
My God.
so
Is there precedent for this? What happened?
This is
this
very-
is what it is. Is it legal gray water? And you know what I mean? Is there any
gray
I
water.
don't know what it's
I'm like, isn't that
called.
poop water?
Yeah.
Gray area?
Non-potable.
Okay. I don't know that there's precedence for this. So based on this discovery from the defense team, they moved to dismiss the murder and leaving the scene charges still pending against Karen. And then they asked that the jurors be brought back in to confirm whether or not they were unanimous on those counts. The judge denied the request, which I can't say that I disagree at this
Well, they've,
point because
talked to a lot
given
of
the
other people.
procedural
Yeah,
status.
yeah, yeah.
So Karen's team appealed, and the issue is currently pending before the Massachusetts Supreme Judicial Court. Oral argument was held on November 6, 2024, but a decision has not yet been made. I did find audio of the Supreme Court argument. Oh my gosh.
Jeez, Marina. I hate you. I'm gonna pause.
Okay, I don't know if you just heard the soul leave my body again, which is funny because I was actually just about to tell a story about that's the Supreme Court argument is what I was listening to when my soul left my body. It was so quiet and it cracked up. Okay, but this is the second time that my husband has scared.
Who lives here? He lives in this house.
Okay, well, the first time he was in the window and that
he
doesn't
owns
belong outside, though. He
owns
doesn't
out
belong
there, though,
outside
too.
at the window in the dark. But
That one he was trying to scare you, so that one's fair.
he's near us and he was coming around the corner to be like, can I make a little bit of noise? Because you guys have been talking,
For a long time.
And I saw him out of the corner of my eye and it scared the shit out of me. And then I scared the shit out of Laura.
Yep.
And then
And here we are. After we took a nice pause, we took a few deep breaths. I think we're ready to I have no fucking clue where you were, but
okay. We're still waiting for a decision from the Supreme Court. It hasn't been released. Okay. So I listened to some of it. I think here's where I want to be. Listen to some of the Supreme Court argument from the questions asked. Basically, they were. All right, let me start over. So I was an appellate lawyer.
Yeah.
And a lot of times when I was getting questions from the appellate court, you have to think about it like they're giving you an opportunity to give them the answer that they need to decide in your favor. Like a lot of people are like, oh, they're trying to attack me and they're trying to poke holes in my case. And sometimes they are, but a lot of times it's like, well, how are we supposed to do this? Like, tell me how we can do this procedurally. So the questions that I heard, the audio was really terrible, so I couldn't listen
That's
to
why
a
you
lot
had
of
it
it.
all
But
the way up.
yes, and then I died. But it was basically like, how is it double jeopardy when there's no verdict? Like, there is no acquittal. How can you say it's double jeopardy? Like, you need the actual verdict for it to be double jeopardy. And
Wait, did I miss something? Because hold on. So come back to what the verdict ended up being. They declared it a mistrial.
on all three counts.
Because they didn't know, and then they said they can't bring the jury back in because they've like talked to people and it's sketchy.
Well,
or
not
whatever.
just
They
that.
can't-
Like,
yeah.
there's no legal proceeding to do that.
Okay. So it's left as a mistrial. And then what is happening what's the appeal?
So her attorneys filed a motion to dismiss the second-degree murder and the leaving the scene charge,
which were the ones
arguing-
that they were not hung on.
Correct. They
Yep.
were unanimous
Okay.
to acquit
Yep,
her.
yep.
They're arguing that that is double jeopardy to put her back in front of a jury on those
Right.
issues because her jury was unanimous to acquit her. But there was no verdict.
So it's funny because like the verdict is only the verdict when it comes in,
Yeah.
right? Like it's not a verdict just because you talked about it in the room, which if you
Correct.
watch 12 Angry Men, they came to like 15 different verdicts, you know?
Yeah.
Oh, that's fascinating. Okay.
So the Supreme Court was like, how is it double jeopardy? There's no verdict. And basically her attorneys were like, listen, we get it. We're not asking this court to enter a judgment of acquittal.
Right.
We are asking this court to say we are remanding to the trial court for further proceedings to determine what the jury's verdict was on those charges. Like, they're looking for the Supreme Court to help them in getting the jury back to prove that they were unanimous. Like, it's very
And there's
interesting.
nothing, like literally no case has ever happened like this before.
I can't
I
imagine.
mean, not that you know every single case ever anywhere.
I didn't do
but,
any legal research on it, but I would imagine that.
I mean, they must have. So
Yeah.
that's insane. It's just an insane thing because if you even back up to like we're talking about, is this a conspiracy? Is this like why are we even on trial in the first place? Like back at the
Right.
original trial. But putting that all aside, it's like, you know, did that foreperson do it completely innocently? Like they
Right.
genuinely misunderstood? Because like as a layperson, I don't think I would fully know I mean, I would hope that they'd have a lot of things, and I know they have a lot of things explained to them, but I don't think I would I mean, I bring you things all the time, like, oh, I forgot to tell you this piece of information. You're like,
Right.
that's actually the most important piece of information. But I wonder if they, like, did they have literally no idea? Did they genuinely not realize the impact that would have? Or you could go the other way and say, are they like pro police at all
Right.
costs? And they're like, oops, you know, and that's pretty egregious to say that.
You're
but
also kind of a dick if like two jurors are like, I think we should send a note that we can agree on
that's
some of
so
it. And the
sketchy.
person's like, no, we have to be unanimous on
what
all of them.
But what did that actual conversation look like? Was it like, oh no, here's what we're supposed to do? And like
Right.
if that person was seen as a person who knows what they're talking about and they said it confidently, maybe as a juror, you're like, oh, okay, I didn't realize that. Like, I don't know.
It's so crazy though, because they have verdict forms for
Why
each
don't
of
they
the
record
counts.
it? Why don't they record?
Because the deliberation process is, there's a veil of secrecy. Like they do not, after the fact, they can talk about it if they want to, but you're not supposed to know at all what goes on in deliberations.
I guess that is for the better good in general.
Preserves the judicial process.
Wow. Wow. I'm really angry you're doing this case now and not in like a year and a half, because I'm hoping that maybe we would have different answers. So you will have to do an update.
Yeah.
Wow. Wow.
They have, you know what kills me though, is they have verdict forms for each of the counts. So if it were me, like if we were the four people, I'd be like, oh, okay, here's the three counts. Like, how's everybody on count one? Oh, okay, everybody is not guilty. Okay, let's fill this one out. Okay, how about count? Like, I would be like, let's complete the forms we can, and then move on. So it's very weird. It's just a weird situation to be in.
So bizarre. And then it's so that's bizarre. And then like, yeah, it's just, and then it's crazy because if thinking about which way the decision goes. So if they rule it that it would be double jeopardy, that she's safe from those two counts, she's still going to have to go back probably for manslaughter. But then there's still this open Fed case on the whole conspiracy, like poor investigation thing. And then if it's not judged that it would be double jeopardy, then she's back on trial for all three, including second degree murder. How can you get second degree murder and manslaughter? Aren't they talking about the same thing?
It depends on the elements.
Oh, right.
Yeah.
What are elements?
Like the with intent.
Oh, right.
Intoxicated.
Oh, okay. Okay. Thank you.
You're welcome. So actually the ACLU of Massachusetts wrote an amicus brief in support of Karen's double jeopardy argument. That basically means friend to the court. So they're joining Karen's argument and writing in a brief in support of her argument to help assist the court in making their decision. The brief stated that the trial court had a clear path to avoid an erroneous mistrial, simply asked the jurors to confirm whether a verdict had been reached on any count. Daniel McFadden, Massachusetts ACLU's managing attorney, said the organization filed this brief to highlight serious constitutional concerns about the trial court's process.
Well, yeah, because you're not asking them to come back in and then like redo what the court is. You're saying for the appeal to enable that it would be double jeopardy to say, yes, we had unanimous count. You're not like actually changing the verdict, right?
Correct.
You're just saying, yes, that was legitimate, and therefore it would be double jeopardy.
But it's just hard though. Imagine calling these 12 people in, okay? And you have 6 people saying we were unanimous. What if you call them back in now?
Right.
And someone's like, no, I didn't agree. I was pressured or something like that.
Yep.
Like then you're fucked anyways.
Or they're stressed or they lie.
Or they got to it. Yeah. Somebody got to them. Like it's just
people we're good people and I would not lie on the stand or in any place where I'm not supposed to lie. But a lot of people lie. A lot of people lie about really serious things and you can't do anything about it.
a lot of people lie about like really inconsequential things too. And you're like, why?
Yes,
Like
exactly.
why die on that hill?
Yeah.
I just don't understand.
Yeah.
After Karen's mistrial, Canton Police and Massachusetts State Police disciplined some officers. Michael Proctor was suspended without pay.
Good.
His supervisor, Yuri Buchanan, lost 5 vacation days.
Okay, that's infuriating. But I was gonna say also, like, yes, he's very much at fault, but so is everybody else who was
I know.
like, "Oh, that's okay.
Yeah.
You're fine."
And Kevin Albert was suspended for 3 days. Also after the mistrial, John's family filed a wrongful death suit against Karen, the Waterfall, and CF McCarthy's, seeking at least $50,000 in damages for
Why the waterfall? That's
the bar for over serving
Oh my
Karen. They
God,
allege.
come on.
Yep. They said for conscious pain and suffering and profound emotional distress.
I'm sure those things existed, but like you said, they're just going after people that Karen has no more money.
No, I
okay,
know.
all her money has been given to lawyers.
Karen says that if this was about John, the family would have sued her years ago. They only filed the suit once she walked out of court a free woman. And Karen is most hurt by how John Sr. turned against her. She said the two used to go to Sunday church together and then take John's nephew to breakfast. Just 1 month before John's death, John Sr. wrote Karen the following Christmas card. Dear Karen, my mother always told me if you want to tell somebody how you feel, do it in a letter. So here goes. I finally figured out who you are. You're an angel sent from heaven. And thank you so much for all you do. You are the best of the best. Love forever, Papa.
I'm so sad. I'm so sad for this woman who, and you know what? She isn't walking. I mean, technically she's
Yeah,
walking out a free
right,
woman,
right.
but like she isn't.
Right.
She has this hanging over her
Correct.
head, and it's not like some distant future thing. Like
Right.
they're like probably fucking. It's like a hornet's nest.
Right.
Like they're going to go after her now.
Oh, there's more. There's
Oh
more.
my God.
So Karen said about him. Let me finish that thought.
Okay.
Karen says it's easier to fool someone than convince them they've been fooled. Is what she said about that. So she's really sad. As of today, Karen's second trial is slated to begin in April 2025, and she currently has about $5 million in deferred legal costs hanging over her head.
Oh my God.
Apparently, the district attorney's top prosecutors have refused to retry Karen. So the DA retained outside counsel to prosecute her for the second time, Hank Brennan, who defended notorious gangster Whitey Bulger.
Oh, that's who her prosecutor is.
Yep.
All of this is so insane. It is awful because it like literally should be a movie. But that says a
I think
lot.
it's gonna
that
be a movie.
Well, yeah, that says a lot. But they love Boston for movies. Love it.
Oh, I know.
And how can you not? But the fact that those DAs are like, fuck this. You know, they looked at all this and said, absolutely not. There's no way I can win this. And then how do you even find a fair trial at that point? Like,
Oh,
I mean,
I
I
know.
didn't hear about it, but normal people probably did.
Yeah.
But real, wow. Okay.
So at the end of the day, let me just sum this all up.
Yes.
I can never not have reasonable doubt.
Right.
Like,
Yes.
even if there wasn't a frame job, the police were
Exactly.
like Solo cups in a paper bag. Like, are you fucking kidding me?
Yep,
Like,
yep.
no.
And that's why I'm saying I almost wish they hadn't gone after. I think you should stand up to something like that if
Yeah.
there is that much of a conspiracy. But I almost wish they hadn't gone directly at that. And like, is that too much for the jury? Do you know what I mean? Like,
Right.
if they had purely gone against, like, still call out where there's bullshit evidence or evidence planting. Like, I guess you can't really do that if you're not saying it's. I don't know. I almost wish they hadn't. Would it have been more cut and dried? I don't know. But I agree.
Yeah. I don't know. Insane.
Without a doubt, reasonable doubt.
Yeah. Although, really, at the end of the day, I do think it was a frame job.
I mean,
Which is horrifying,
Very,
but
very. Now, timing
bad.
is going to be interesting because I have to imagine that Fed investigation is not going to be done by April. So it'll just be interesting when those result, like that whole thing, right? You said
Yeah.
that's still ongoing, right?
Yeah. And I don't know. I don't know what's going to come of that. I wonder. I don't know. I don't know what they're going to be able to prove. But
Man.
I don't know. It's wild. Like, I actually was laughing listening to
Yeah.
the trial testimony. Like, when the defense was giving when he was giving his closing argument, he was like, and you heard from Lieutenant Tully who had the evidence bags. Well, evidence bags with evidence tape. Who knew? At least they're not Solo cups. We moved on from that. Like, it was actually comical.
Yep.
Comical.
Wow.
But anyways, so that was the trial of Karen Read. The first trial
Damn.
of Karen Read.
Wow.
And there's another one coming.
Wow.
There's a storm a coming.
I'm nervous. Yep.
Okay.
Verklempt.
You're reclaimed. Okay. If you're enjoying listening to Grimm, please rate and follow us wherever you listen to podcasts to make sure you don't miss any episodes. If you listen to us on Apple Podcasts, make our day by leaving us a written review. You can find our page on Facebook by searching Grimm: a True Crime Podcast. If you want to subscribe to our Patreon, you can go to Patreon and search Grimm: a True Crime Podcast. That may be where a P-Boney on an update comes up on this case
That's
in
what I
the
was
future.
thinking.
In
Yep.
the future. If subscriptions
Closer.
aren't your thing, you can buy us a coffee at buymeacoffee.com/grimcrime podcast. If you donate $5 or more and you remember to send me your address and name so that I don't send your sticker to some random name, we'll send the first 200 donors a 4-inch Grim die cut sticker, and it's pretty sweet. Follow us on Instagram at Grim Crime Podcast for information on future episodes and case photos, which I will update. If you want to send us a case suggestion or just say hi, you can email us at grimcrimepodcast@gmail.com. Listen, learn, and stay alive until next time, because the future is grim.